Part 1: Termination of Construction Contracts in Indonesia. Legal risks for developers and contractors. When can a construction contract be terminated? Managing legal grounds, procedure, and risk. Contract termination is increasingly becoming a commercial reality. Construction projects in Indonesia are becoming larger, more complex, and subject to tighter delivery schedules. At the same time, developers and contractors are facing growing operational challenges, including financing constraints, supply chain disruptions, regulatory compliance issues, and changing project requirements. In this environment, the termination of construction contracts has become an increasingly common outcome when projects encounter significant delays, cost escalation, or performance failures. Termination of a construction contract is rarely a purely contractual matter. It often triggers immediate legal, financial, and operational consequences, including suspension of work, enforcement of performance guarantees, and disputes among project stakeholders. From a risk management perspective, understanding when and how a contract may be terminated has become a critical issue for project participants operating in Indonesia's construction sector. Grounds for termination under Indonesian construction contracts. Construction contracts in Indonesia typically provide specific circumstances under which either party may terminate the agreement. These provisions are generally aligned with contract principles under Indonesian law, where termination may be justified when a party fails to perform its obligations or commits a material breach. Common grounds for termination may include prolonged delay in project completion, failure to meet contractual performance standards, insolvency or financial distress of a party, failure to maintain required licenses or regulatory approvals, material breach of safety or compliance obligations, suspension of work for an extended period. While these grounds are often set out in the contract, disputes frequently arise regarding whether the legal threshold for termination has been satisfied. Procedural requirements. Why process matters as much as substance. Even where valid grounds for termination exist, failure to follow the required contractual procedure can invalidate the termination decision. Termination provisions typically require formal written notice of default, an opportunity for the defaulting party to remedy the breach, compliance with notice periods, documentation supporting the decision to terminate. Failure to comply with these procedural requirements may expose the terminating party to claims for wrongful termination. In practice, many disputes arise not because termination was unjustified, but because the termination process was handled incorrectly. Termination for convenience, a strategic but risk-sensitive option. Some construction contracts allow project owners to terminate the contract without alleging fault, commonly referred to as termination for convenience. While this mechanism provides flexibility, it does not eliminate financial obligations. Contractors may still be entitled to compensation for work performed, demobilization costs, reasonable project-related expenses. Termination for convenience should therefore be treated as a commercial and legal decision requiring careful evaluation. Performance bonds and guarantees, immediate enforcement risk. Construction contracts commonly require contractors to provide performance bonds or bank guarantees as security for project completion. Upon termination, project owners may seek to enforce these instruments to recover losses or ensure project continuity. However, disputes may arise where contractors believe termination was premature or unjustified. Since performance bonds are often payable on demand, enforcement can occur quickly and create immediate financial pressure. Early legal review is often essential before taking or responding to enforcement action. Regulatory and compliance considerations. Termination of construction contracts may also involve regulatory implications, particularly where projects are subject to licensing and safety requirements. Relevant oversight may involve authorities such as the Ministry of Public Works and Housing of the Republic of Indonesia, or local government agencies responsible for construction permits and compliance monitoring. Non-compliance with regulatory requirements may contribute to termination decisions and expose parties to administrative sanctions. Conclusion. Termination of a construction contract is rarely a single decision point. It is typically the result of operational, financial, and legal pressures that develop over time. Understanding the legal grounds and procedures for termination is essential to minimizing risk and avoiding unintended liability. In Part 2 of this series, we examine one of the most common and commercially sensitive scenarios in construction projects, termination arising from non-payment by the project owner, and the legal mechanisms available to contractors seeking to recover costs and protect their financial position. If you, a prospective client, have further inquiries about the topic discussed above, Schinder Law Firm is one of many corporate law firms in Indonesia that has handled numerous similar matters, with many experienced and professional corporate and civil lawyers in its arsenal, making it one of the top consulting firms in Indonesia. Feel free to contact us at info@schinderlawfirm.com for further consultation.